Good morning, everyone. My name is Stephanie Reel, and I am with the New Jersey Business and Industry Association. Thank you so much for joining us for today's webinar, which is going to concern sexual harassment in the workplace. Now, before we begin, we just have a few housekeeping issues. The first is that we are recording this webinar. So if you want to go back because maybe you've heard something that you want to hear again, you can do that by going to our website, njbia.org. In addition, your lines are going to be muted during the presentation, just so we don't hear background noise or anything like that. But don't let that stop you from asking a question. If you want to ask a question, you can go ahead and type it in and we will read the question, or you can wait until after we're done with today's discussion and then you'll have an opportunity to ask it out loud. So without further ado, I'd like to introduce everyone to our speaker for today's webinar. That's Kathleen Connolly. Kathleen is an employment and labor attorney from the law firm of Lindaberry, McCormick, Estabrook, and Cooper. So Kathleen, wow, what an interesting time to be an employment and labor attorney.
It certainly is. It certainly is.
So I think everybody that's listening has heard all about the MeToo movement and the Time's Up movement. So it seems like every day we are turning on the news. As recently as last night, there were accusations against Scott Baio. And I just feel like we keep hearing accusations against Hollywood moguls, against members of Congress, against big CEOs of corporations. Presidents. So can you tell us exactly what types of behaviors are we talking about here when we're talking about workplace sexual harassment?
Okay, there are essentially two forms of workplace sexual harassment that can occur and can give rise to a hostile work environment. The first form is when a supervisor or someone with authority over your work makes a sexual advance towards you, and whether or not you succumb to that sexual advance is the determining factor in whether or not you get promoted, you get the job, you get a good or favorable performance review. So if you give into it, it's all good, and you will get that tangible employment advantage. If you rebuff that advance, you find yourself on the street, looking for a job, not getting the promotion, not getting the raise. It's called technically quid pro quo harassment. And if you took Latin, you would know that that means this for that is what that means. But it's easier to think of it as, put out or get out.
Oh, okay.
Right. And it's when someone with authority uses that power over you to get you to do something that you didn't want to do and succumb to a sexual advance. And that's the kind of harassment that we saw illustrated by the Weinstein situation in Hollywood.
Okay.
The Hollywood starlets were saying, he is so powerful that in order for us to get any kind of work in Hollywood, we have to let ourselves be subject to his sexual assaults, his deviant sexual behaviors. Because if we don't have a shot in Hollywood.
Yeah. Well, you said that that's one type of
Correct.
harassment. What's the other type, and is that more common?
Yes, the second type is what we call hostile work environment harassment, and that is much more common. It can be engaged by anyone in the workplace environment. It doesn't have to be a supervisor. And it's the kind of sexually charged workplace behavior, be it verbal, be it physical behavior, that makes the individual feel uncomfortable in the workplace and that the workplace has become hostile. So if you think about the Al Franken situation, that was claims of the kind of conduct that gives rise to a hostile work environment. He wasn't accused of using his authority as a senator to basically extort sexual favors from women. What he was doing was he was engaging in touchy-feely behaviors that were not wanted. He was using photo ops as an opportunity to put his arm around women and then slide his hand down and pinch their buttocks. He was using closeness to individuals and women to perhaps cop a feel, grab a breast, for lack of a better word. And so obviously, if you're in a workplace and you have somebody who's groping you, you're going to feel very uncomfortable in your workplace. And you're going to feel that the workplace has changed to such an extent that it has become a hostile one. Now, it's important to remember that hostile work environment isn't just limited to this touchy-feely behaviors that Al Franken was accused of doing. It also incorporates any kind of sexually charged conduct in the workplace. So it could be the office clown. The guy
So it can be verbal.
Correct. It can absolutely be verbal. And it can be the guy who constantly tells those racy, sexual jokes that maybe you don't appreciate. Now, maybe you don't tell him you don't appreciate it, but inside you're saying, gosh, I wish he would just shut up. I don't want to hear that kind of joke, and I don't think it's funny. It could be the office creep, right? The guy who lurks in the shadows, who gets a little too close when he talks to you, who leers at you, who makes sexual innuendos to you. Again, if that continues to happen in your workplace, it's going to start making you feel uncomfortable. And so it gives rise to this hostile work environment that we're talking about.
So we talked about the verbal comments, and I want to focus on that for a second, because I know the question that we always get is, so does that mean that the gentleman that makes one offensive joke or that makes an off-color comment is guilty of some sort of harassment?
Yeah, no, not at all. There have to be three elements that have to be present in order for it to rise to a level of actionable sexual harassment in the workplace. And the first element is that it has to be unwanted conduct. Now, all of these laws that we talk about, anti-harassment laws, are only aimed at getting at non-consensual conduct. They're not aimed at stopping individuals, grown adults, from engaging in entirely consensual interactions, be that a workplace affair, be it a group of guys at the lunch table or gals at the lunch table telling the dirtiest jokes they can possibly think of. As long as everyone in that environment is comfortable with that exchange and is consenting to that exchange, no harm, no foul. But Stephanie, as you can imagine, there's a lot of risks with that, if you think about it.
Right.
For two reasons, two main reasons. First of all, if you're engaging in sexually charged conduct in the workplace, how are you sure that the people you're displaying that conduct in front of actually find it consensual?
Right.
So, again, if you're sitting at a table with a bunch of your colleagues, and one colleague is telling really offensive jokes, almost everybody at the table will probably chuckle. But maybe one or two people at the table, while they're chuckling outwardly, inwardly they're saying, gosh, I really don't appreciate that. But it's hard to stand up and chide your colleague and say, I don't really appreciate that behavior. Because then you get tagged as what? The buzzkill, the prude,
the tattletale.
The tattletale, not the team player, exactly.
Right.
So, you don't know whether it's consensual or not. You really don't. And the second risk that's there is, we all have to remember, your friend today, unfortunately, can be your enemy tomorrow. Right. And I hate to say that people turn the tables on you, but I've seen it happen. So, for example, if a supervisor is having an affair with a subordinate, and then when his wife finds out, he has to end it, well, what do you think that subordinate might do?
Right.
Claim that this wasn't a consensual affair after all, that I felt pressured to engage in the affair, and I felt that if I didn't give in, I'd be fired.
Right.
So again, engaging in any kind of sexually charged behavior in the workplace is fraught with risk. And I try to tell people, look, don't do it with people you work with. It's just too risky to do it.
What about if I'm having a conversation in the lunchroom, and perhaps it's not the best conversation, not so appropriate for work. Not that I would ever do this, but I'm going to use myself as the example. So not the best conversation at work. Somebody walks into the lunchroom while I'm having this conversation with you, we're talking like old girlfriends, and the person is made to feel uncomfortable by the content of the conversation that we're talking about. Is that harassment?
Well, that can be, and that's what we call bystander victims, meaning the conduct isn't directed at me personally, but it's happening in my work environment, and I don't like it, and it makes me feel uncomfortable. Now, it is not a defense for that group over there to say, well, we weren't talking to Kathleen. Why doesn't she mind her own business? Why doesn't she go eat lunch in her office. No, this is my work environment too. And if I'm being exposed to these behaviors that I have a legitimate basis to claim are offensive to me, then if I bring that to my employer's attention, they need to address that behavior and indicate to those individuals they need to stop engaging in it. But I want to go back, because remember we started on there have to be 3 elements?
Yes, and we only covered 2.
Okay, well, we only covered 1. It has to be unwelcome behavior, right? If it's consensual, no harm, no foul. It has to be unwelcome. It also has to be so severe or pervasive that it becomes actionable. Because not every incident of inappropriate behavior is going to rise to the level of actionable harassment. So I'll tell you by way of example. You used telling one dirty joke. If Kevin, my colleague, tells one dirty joke to me, and it's a mildly offensive dirty joke, do I have a claim to say I'm being sexually harassed by that? No, because the law says, well, wait a minute, that's not sufficiently severe. It's a mildly offensive joke, and it only happened once. So it's not actionable sexual harassment, because it's not severe or pervasive enough. But if Kevin tells me a dirty joke every time I see him coming down the hall, to the point where, you know, you get that visceral reaction.
Right.
Oh gosh, I want to duck into this hallway because I just don't want to hear it from Kevin, the dumb jokes he's going to tell. Well, that's when it's become so pervasive that my work environment is changed because I'm reacting to him and I don't really want to be around him. Okay, so that's where it's severe enough that it could constitute sexual harassment. Now, let's say Kevin groped me in a conference room. Well, the law doesn't require me to be groped several times before I have a claim. That's so severe, that kind of conduct, that one instance is enough to give rise to what could be a hostile work environment. So we have first element, it's got to be unwelcome. Second element, it's got to be severe, pervasive. The third element is that the conduct, whether it's offensive or not, is going to be judged by what we call the reasonable victim standard. So if the victim is a woman, it's going to be how would the reasonable woman react to that conduct and would she find it offensive? If the victim is a male, we're going to say how would the reasonable male react to that conduct? If the victim is a gay person, how would the reasonable gay person react to that conduct? So, you know, for obvious reasons, depending on your status in one of those groups, you may react very differently to the behavior in question. Secondly, it protects us from having the super sensitive individual having a claim. So for example, if someone asked me out on a date at work and said, would you like to go out for drinks after we finish up? Would I be justified in saying, oh my gosh, I feel I'm being sexually harassed? No, because the reasonable woman wouldn't think that that was the case.
Right, the overly sensitive might, but not the reasonable.
Absolutely, that's correct. However, if every single day or week after week the same individual is constantly saying, come on, let's go, please, I really like you, I want to go out, and they're not taking no for an answer, well, now
that's unreasonable.
Correct. A reasonable woman would say, you know what, you're really harassing me because I said no, and no means no. So that's where we have the 3 elements, right? Unwanted, severe and or pervasive, and as judged by the reasonable victim standard. And if all those 3 elements are met, we are now into unlawful workplace harassment.
So we've talked about harassment in the confines of these 4 walls, of actually being on the site. What we find often happens is that 2 employees become friends on Facebook, and then something happens out of the office. And can that still be harassment, or does it actually physically have to happen in our building to have it be harassment?
It absolutely can happen anywhere. And where it happens, or by what method it happens, be it face-to-face, be it off-duty, be it on-duty, be it vis-a-vis Twitter or Facebook, it's not really the question. The question is there enough of a connection to the workplace in order for it to trigger an obligation on the employer's part, that if the employee complains about it, the employer is obligated to do something about it? So I guess the best way is by way of an example. If it's 4 o'clock in the morning, and you know nothing ever good happens at 4 o'clock in the morning, and I get a ding on my phone that I've received a text message. And I open it up, and it's a picture from a colleague, and it happens to be a wiener picture.
A wiener picture.
Anthony
Weiner, okay.
Anthony Weiner, literally, yes.
A wiener picture.
It's an Anthony Weiner type of photo op, straight from the waist down.
We could go in so many different directions there.
Right, and so obviously offensive to me if I didn't want it. Now, it wasn't during work hours. It's not work related really, right? It's off duty. It's at 4 o'clock in the morning. But there's enough of a connection to work because I work with this person, and you better believe
You're going to have to see them at 9 o'clock.
Absolutely,
right?
Absolutely. So if I bring that into work and complain about it, yeah, my employer's going to have to do something about that because we have to work together. But if I give you a different example, let's say that the message that came across, the Wiener photo op, was from a friend of one of my colleagues that I happened to meet at his house. He's not a client of the company, and he just happens to be somebody I work with's friend, my boss's friend, let's say. In that situation, there's not enough of a connection to work. It's just the only connection is he happens to know my boss. Right. So in that situation, it wouldn't be workplace harassment. But the bottom line is that, individuals have to be very careful about engaging in off-duty conduct on either personal or work-owned devices, because these behaviors, if there's enough of a connection to work, it can get you jammed up in the workplace, and it can get you facing a charge of harassment.
So whether it occurs in these four walls, at a bar, or over some electronic kind of space, the employer still has to take some sort of action if there is some sort of an allegation then.
Yes, if there's enough of a connection to the workplace.
Okay.
Right, there has to be a sufficient connection to the workplace for it to occur.
Now, we've talked a lot about coworker to coworker interactions. Can we talk a little bit about the boss interactions, and maybe not anything that's as overt as we spoke about with members of Congress or with the media, but maybe something like a boss who is just a real bulldog, comes in and is intimidating, gets things done, but maybe is a little bit brash in their tactics. When does that become a harasser versus just a high performer?
Okay, so you're talking about what we call the bully, right?
The bully.
The bully in the workplace. Being a bully in the workplace, at least at this point in time, in and of itself, is not unlawful. It's not unlawful harassment. So, for example, if you're the tyrant who runs around the office and gets into temper tantrums, and the temper tantrums are laced with colorful language, and you scream at individuals, males and females alike, and on one day you get up into the grill of Susan, and you say, "Hey, Susan, what the blank do you think you're blanking doing? I'm sick of your blanking blank. You're a blanking idiot." Is that sexual harassment? Probably not. Unless there was evidence that the bully only did that to females. But if the bully does that to everybody,
They're an equal opportunity?
they're an equal opportunity
To the offender,
bully.
yeah.
That's exactly right. They do it to everybody. But, I think we can all agree that that's wholly inappropriate behavior. And it should not be tolerated, even if it is just straight up and up bullying. And, I don't know about you, but when I was young, if I went home and told my dad that the teacher yelled at me, in my face, yelled at me, what do you think my dad said?
What'd you do?
That's exactly right.
We were raised in the same house.
What did you do? And if I said nothing, he'd say, well, you know what? Shake it off, because it's for the time that you did do something and you didn't get caught. And that was the end of it, right? We have changed as a culture, right, dramatically. And rightfully or wrongfully, and I think more rightfully, people don't put up with being treated that way. And there's no reason to be treated that way in the workplace. And, because employers haven't caught on to that and they're tolerating this kind of behavior, that's why we're seeing the spread of these Healthy Workplace Act statutes, the anti-bullying statutes. And they're trying to make this bullying get at this concept and make it unlawful. 3 states have passed it. It's come up before our legislatures several times. Hasn't passed yet. But if people keep engaging in these behaviors, we're going to see that will be the new frontier, the new set of laws trying to regulate that kind of behavior in the workplace.
So right now, we don't have an anti-bullying law in New Jersey.
No.
But when we talk about harassment, and even with this renewed interest that we've seen by the MeToo movement, has the legal standard changed at all?
No. Legal standard
okay.
is still the same, but there has been a big change. The change has come in both the awareness that individuals now have as to what kinds of conduct constitutes sexual harassment, and also the tolerance level for it in the workplace. And the MeToo movement, certainly illustrates that sea change. Because on the one hand, you have a lot of the MeToo women who are saying, especially if we're talking about the more subtle behaviors, they're telling stories of saying, I didn't even know that when I was being the victim of all that sexual innuendo, that was unlawful. I didn't even know I could complain about that and get redress. But now they know, and they're telling those stories. On the other hand, you have those women, especially if we're talking about the more offensive behaviors, the physical gropings and things like that, they may say, yeah, I knew full well that conduct was unlawful, but I was afraid to say anything. I was afraid for a couple of reasons, the reasons we talked about.
Right.
I'm afraid of getting fired, or I'm afraid of being looked at.
Right, the reputation.
Right.
Yeah.
Right, or getting somebody that everybody else likes fired, or a troublemaker. So, women weren't telling their stories before, but now, thanks to the movement, to quote Oprah, time's up, it's the dawn of a new horizon. They're now being empowered to come forward and complain about things in the workplace that are making them feel uncomfortable. So, there's no doubt that the movement has clearly gotten the world's attention. And now, when women complain, they pretty much have an instant cloak of credibility. They're being believed at the outset. Right. And that's a great place to be. So it's been a wonderful development, actually.
But, to play devil's advocate, do you see any negative repercussions for women in the workplace as a result of this?
Yeah, it's a little early to tell, and I hope not, but I'll tell you why I do have some concerns. Whenever I do training, ultimately, I have someone, and it's usually a male, who will say, oh, that's it, I'm just not going to say anything to anybody anymore, I'm just going to keep to myself.
Right.
I hope that the pendulum hasn't swung too far, where we're in a situation where men begin to alienate women in the workplace.
And how so?
Well, for example, not having any one-on-one meetings with a female, right? That would be not a good thing, because you have to have one-on-one meetings to get work done.
Right.
Perhaps not inviting women to the lunch engagement with clients or the after-hours networking event, because you don't want to be accused of harassment. If you remember, it's the Mike Pence rule.
Right.
Are you aware of that? Our Vice President, Mike Pence, indicated that he has a rule that he won't meet one-on-one with a woman unless his wife is present. He will not go to an after-hours function if alcohol is served if his wife is not present. He got lambasted for that, criticized very highly. But in this environment, some people might think that's an understandable position for him to take. He's protecting himself. I hope we don't get to that point where there's an overreaction. And has it gotten to the point where engaging in simple human interactions, appropriate human interactions, like, you look nice today, that's a nice dress you're wearing, red's a good color for you. We are social creatures, and it would be a shame if we get to a point where people feel stifled that they can't even do that with people that you see every day. Now, I think maybe we'll have some moments where that happens, but I think in general, and I hope, that most men, and most men do behave appropriately in the workplace, they will continue to not be afraid to interact with women on a professional level on an equal basis. And that we continue to be treated as equals in the workplace, and that this doesn't have a chilling effect on that.
Yeah, well, let's, if we can, go back to your comment about that's a nice red dress.
Yeah.
So suppose someone makes a comment to me about my appearance, and I am, for whatever reason, maybe because I'm sensitive Stephanie, I am offended by it, and my employer goes and investigates, and the person who made the comment says, that was just a compliment. Everybody knows that the S in Stephanie is for sensitive. So what does the employer do in that situation?
Well, that's where this reasonable woman standard is going to really come into play. If the evidence, and the employer has to look into that, and if the evidence suggests that this was merely an appropriate compliment on red is a good color for you to wear, your reaction that you were being harassed, most women would not find that to be a reasonable reaction. It's just a simple compliment. Okay? However, if the evidence suggests that that compliment about the red dress was accompanied with sliding the hand down the back and placing a hand on your buttocks, well, now it's not just a simple compliment. It is coupled.
Some sort of physical.
That's right. Or it doesn't have to be physical. It could be a leering. It could be the way it said, oh, you look hot in that dress, right? The way it's said. It's got to be accompanied with something that makes it go from a simple compliment into an inappropriate, sexually charged compliment or behavior. So that's when it crosses the line.
And in that case, where you find that it is an inappropriate, sexually charged behavior, are there second chances? Is there such a thing as a second chance?
Whether or not you get a second chance depends on a lot of things. First of all, it's going to depend on the gravity of the conduct. And then it might also depend on the wishes of the complainant, and I'll explain. So if you take the situation where Kevin says to Susan, wow, you look smoking hot in that dress since you lost all that weight. Inappropriate. Would that warrant a termination? I would say probably not. If he had never done it before, it's inappropriate, it would warrant a warning, probably. Because it's not severe enough to warrant a termination. However, if Kevin's comment was, you look so smoking hot in that dress, and it's now accompanied with sliding the hand down the back and resting it on her hip, well, now that's going to warrant a more severe sanction because you've engaged in offensive touching. So maybe that's a termination, especially if it's a supervisor. Maybe the discipline would be greater because remember, supervisors are charged with enforcing your policy. And here's your supervisor violating the policy. And certainly if it was coupled with actually putting the hand down the back of someone's trousers, that's a termination in most circumstances, because it's so severe that you don't get a second chance in that situation.
Right.
So, and why I say sometimes I will consider the feelings of the complainant. In the third example, where it's an atrocious sexual assault, no, you don't get any second chance. But in the other certain situations, many times the complainant, and they mean it, they say, I don't want this person fired. Sometimes they even like the individual. They just want that behavior to stop. They don't want to see this person lose their job. So in those situations, if it's a bit of a close call, but I'm confident that the complainant doesn't want to see the person lose their job, and that they can continue to work with this person, and I think that this person can be cured and will listen to a firm warning or some other measure of discipline, I might be more inclined to say, okay, maybe this will work. And so maybe you do get a second chance. It's going to depend on the circumstances. It's a case-by-case assessment. that has to be done, and that's where the services of a seasoned investigator will help you as an employer come to the right resolution, depending on the nature of the offense that we're talking about.
So in a situation like this, you definitely need to do an investigation, make
Absolutely.
sure that it's fair to everyone involved. How do you make sure that the process is fair? I think that that's a big challenge for employers, especially if they're small employers and they want to try to do an investigation themselves. How do you make sure it's fair?
Yes, you do have to, in any allegation, no matter how insignificant you may think it is, if a complaint of harassment is brought forward, the employer is obligated to conduct a full and fair investigation into that. And the knee-jerk reaction is often you assign it to that person in HR. And if the allegations aren't particularly egregious, maybe that's okay. But there's a lot of problems with that. First of all, is the person that you're looking at qualified to do an investigation? Do they have the skill set to ask the right questions? Do they have the skill set to ask the right follow-up questions? Do they have the ability to assess credibility? Do they know where to look for direct evidence and circumstantial evidence? Do they know how to write fact-finding, engage in fact-finding? Do they know how to write a report? These are not intuitive skills. They have to be learned. I've been doing this for 25 years and I'm still learning, and I'm pretty good at it, but I'm still learning. So, you have to be careful. It has to be somebody who really knows how to conduct an investigation. Because remember, that investigation may be Exhibit A in the context of a lawsuit.
Well, and I would imagine, too, if you have a small office, that everyone is just so close to the situation, how can you be impartial?
Yeah, that's another problem, particularly if the accused is a member of upper management. How does someone who may be in a lesser position investigate that individual? The perception is going to be the fix is in. There's no way I as a complainant going to get a fair shake because after all, there's a subordinate investigating the boss. That's not working. Or as you said, you're investigating somebody you know. So hiring an outside investigator, we come in, I don't know the accused, I don't know the witnesses, I don't know the victim. So I have an objectivity that's built into the situation that's not colored by how my personal relationship might be with these people. And also, a third-party investigator, it sends a signal to your staff that you take it seriously. Because it costs a lot of money to do that.
Right.
So it really shows everybody that, hey, they really stand by what they say. They're not going to tolerate this. And there's another great advantage with third party. You can shield yourself from having to make the hard call. So, for example, if you internally investigate and now you're meeting with somebody who you know pretty well and you're saying, I'm sorry, Kevin, you're going to be terminated. Kevin's going to start saying, well, wait, what about, and you're going to get a lot of pushback. Or if you're meeting with Susan and you're saying, Susan, I'm really sorry, but we didn't find enough to substantiate your claim. Again, you're going to get pushback. But what? If you have a third-party investigator, you say, well, I'm sorry, that's the investigator, that was her conclusion, and these are her recommendations, and we have to abide by that. It takes the heat off of you and ends that discussion pretty quickly.
So now we've seen a lot of accusations coming out. And we've talked about accusations, we've talked about the need for investigations, but what it seems like what's happening now is that someone very high profile in the public eye is accused and automatically a company takes action. So are we getting to the point where an accusation automatically means a conviction?
Yeah, I hope not. As I said before, as a result of this movement, we've had the positive development where women are automatically cloaked with at least some initial credibility when they make these claims. Well, the same should be true of the victim, of the harasser, the accused harasser. If they deny the allegations, they too should be believed until such time that you have some evidence that suggests that they're not being credible. It has to be fair to both sides of the process. And I hope that as a result of this movement, but I think we've seen some examples where employers are engaging in a rush to judgment because Maybe they don't want to deal with the press that's coming out about it.
Right.
They don't want to deal with the pushback.
They don't want to lose sponsors.
They don't want to lose sponsors. They want to be out in front. They want to look like they're really supporting women in the cause. But I hope they don't do that at the expense of not giving the accused at least a fair shake to defend themselves. Now, it's important to remember that an employer, at least in the private sector, absent a contractual obligation, doesn't owe the accused any sort of due process. They are free to say, you know what, we just don't want to deal with it, and Kevin, I'm sorry, you're gone. Okay? But that's not a good place to be. We don't want to be in that situation. And I think, I hope employers don't jump the gun and accord people an opportunity to tell their side. And then, of course, if you find that there's been the allegations are sustained, well, then by all means take the action that you have to. But if you remember, Al Franken was complaining about that very thing.
Right.
If you remember, he said, well, you know, yes, I engaged in this behavior, but it wasn't, it needs some context. It wasn't as egregious as it's being portrayed. Some of it was consensual. He wanted to explain himself, and he was saying, although it was wrong of me to do, it doesn't warrant me losing my Senate And there was going to be a process where a Senate committee was going to look into it. But the pressure that was put upon him was too great. And he reluctantly resigned, even though he said he wanted to engage in that process to hopefully vindicate in some part some of his conduct. So, you know, I think that we want to be in a place where it's fair to everybody, and that employers go through this investigative process so that at least you can show that it was fair. And there is a concept out there, and it hasn't gained much traction yet. And we'll see whether it gets any traction going forward. But for the employers who jump the gun and don't accord the accused the opportunity to defend, the argument is, you male stereotyped me. Mm-hmm. Just because I'm a male, you assumed that I must have done it. And that's sexual stereotyping.
And what can be the repercussion from that?
Well, people try to make that as a sex discrimination claim.
So wrongful termination.
Wrongful termination on the basis of my sex, in this instance being male. And because I was male, you automatically discredited my denial of the accusation.
Because sex is a protected class, right?
That's correct.
So if I get fired because of my sex and I argue it effectively, then you could probably owe me some money.
Potentially. So, you know, whether or not that theory is going to gain traction in this context, I don't know. But just as a matter of just basic fairness, you should give people a shot to at least tell their side of the story, and then you make the call.
So it sounds like now is a really good time for employers of all sizes to look at their policies, to go through, make sure that they have a sexual harassment, hostile work environment policy that's not from the 90s, that has been updated within the past couple of years, and to try to really hone down and hone in on some of the conduct that is going on in the workplace. And I read an interesting article that one employer in particular has banned emojis in the workplaess.
No.
So no emojis.
Don't take away my emojis.
No angry happy face. Can I say that?
Yes.
Because it's an angry happy face, which is a little bit of an oxymoron. But is that going too far?
I mean, at first blush, it seems a little absurd, right? But if you think about it, if you're in the right circumstances, if you're sending that angry face, the red face,
yeah,
the smiley with the heart eyes that are drifting out, the one who's licking, you know, he's got his tongue out and he's licking his lips, the kitten. Under the right circumstances, those silly little images can speak volumes, right? If you think about it. So maybe that's not such a crazy idea. And, you know, I mean, I know I don't use them at work. I kind of think they're kind of unprofessional. But you know, just they can be a trigger for a claim if they're used in the right circumstances. Yeah. You know, you won't go out with me, man face.
Right.
Know, for example.
Right. Well, we've covered a lot of ground here, us talking one-on-one, but I want to give our audience that's listening an opportunity to go ahead and ask your questions.
Oh, wait, before we do?
Yeah, sure.
If you don't mind me
No, please, is there
I did
anything
wanna
else you wanted
hit-
to touch upon?
Yeah, I did want to hit one more point, because there's a few things that an employer can do, very simple things that they can do to help inoculate themselves from a charge of harassment. The courts have recognized what we call a safe harbor for an employer who acts reasonably to try and prevent sexual harassment from occurring in the workplace. And even if it occurs, they say, in most circumstances, if you've done these 3 simple things, you will escape liability. So what are those 3 very simple things? You touched upon one already. Having a written anti-harassment policy in place that contains a complaint procedure, tells people what to do if they have a complaint, who do they go to, okay? And you distribute that to everybody. So check, most employers have that one. They kind of fall short in the next 2. The second element that you need to have is that you need to have periodic training in your policy and generally in the law of sexual harassment. What do we mean by periodic? Don't know. I think that depends on your workplace. Every year is certainly fine. Every other year is probably fine as well. The EEOC says the training should be done live. And I think the reason why they say that is kind of obvious. Those of us who do online training, what are most people doing when they're doing their online training?
Checking their social media,
Doing
answering emails.
You're multitasking. You're not paying attention. Live training, if it's done by somebody who's engaging, is very powerful, and people pay attention. So I think that's why the EEOC says the training should be live, but it's not a requirement at this point in time. It is a requirement in some states, but it's not a requirement here. So you have to have the policy, you have to have the training, and then if a complaint is brought to your attention, you conduct that prompt investigation. And if a violation is found, you take appropriate remedial action. If you do those 3 things, in most cases, not all, but in most, the employer can escape liability, because the courts will say, you did all the right things. You did your best to make this not happen, and you took care of it when it did. We're not going to hold you liable. Now, let's say you have the policy, you have the training, but the employee doesn't invoke the complaint procedure. What happens then? Well, in that circumstance, the court's going to say, under this safe harbor, the courts should say, hey, employee, you didn't keep up your end of the bargain. This is a 2-way street. You were given a policy, it has a complaint procedure, and you were trained that you had to come forward and complain. And you sat silent. You didn't give your employer an opportunity to fix it and address it first. So don't come crying to us. And in theory, the court would dismiss the case in most instances.
So those 3 things.
3 very simple things. Very simple things that every employer can do. And there's sometimes some pushback because it costs money. But my gosh, it's pennies as compared to the cost and the time and effort that you're going to spend if you're having to defend a legal claim.
Right, not to mention the loss of productivity.
That's
Because
exactly right.
Your senior management is now devoted to meeting with lawyers as opposed to working on your strategic thinking.
Absolutely. And you'd be surprised how much better workplaces do become with some good training. People come in, when I give it, people come in that, they're kind of grumbling. Who likes to go to training?
Right.
And I will say by the time they leave, people come up and say, oh my gosh, I'm so glad you gave us that presentation. I learned a lot.
Right, I didn't know this.
I didn't know this.
Yeah.
And maybe I better curb some of my behavior. It's a good thing. It's a good thing. And don't be penny wise, pound foolish. You have to invest in your company, and this is one of the things you need to invest in.
So before we go to the audience, is there anything else that you think that the average small business needs to know?
Yeah, call me. No. No, I think we've covered it, but I think, the audience always has some great questions. So
Okay.
Let's see what kind of surprises they have for us.
Well, don't all talk at once now. All right, does anyone have a question?
No, Trenton and JBIA. But it doesn't look like it. It looks like it'd be more of a screen. Yeah, it must be.
Do we have a question?
We appreciate the NJBIA shout out. Any questions? I know Kim has some.
We have one in the queue. Says here, what happens if one company employer says something unwelcome to an employer from another company? Maybe like an outside vendor?
Great question, and that was an important topic we didn't touch upon. The employer is responsible to eradicate any behaviors that are perpetrated by anybody in the work environment. So it can be the copy guy that comes in to fix the machine who's harassing the receptionist. It can be the client who, when you're going to a meeting, is putting his hand on your leg and moving up towards your crotch area. It can be anybody who has a relationship with the employer. If that person is perpetrating offensive sexual conduct and you bring it to your employer's attention, they have to address it. Great question.
Okay, looks like we had a similar question come in just that you just answered. Another one is, how does an employee/third party decide whether the complainant is lying, or if it's legal action or was verbal and not in the presence of others? So basically.
Okay. Yeah, surprise, surprise. A lot of this conduct happens behind closed doors or not being witnessed by others, and it becomes a he said, she said situation. And again, that's where a qualified investigator is key. When I do an investigation, if it's a he said, she said, do I throw up my hands and say, oh, well, can't figure it out? Of course not. You're going to cast the net out a lot wider. And you're going to say, well, you know what? I'm going to start talking to the individuals who work with these two people. And you'd be surprised. It's usually by talking to those individuals, you get some kind of cooperative evidence that enables you to make the call one way or another. So, for example, it could be as simple as, no, I never saw John grope Kim, but he did something similar to me once. Well, there you have some evidence, okay? So that's usually how you find out. There's usually ways to get some kind of cooperative evidence. It could be, for example, something like, immediately after that encounter that Kim is claiming, I didn't witness it, but she came out of her office and she was extremely distraught. And I flagged her down and I sat her down. I said, what's the matter? She started crying. Well, that's evidence that something happened behind those closed doors. And it's contemporaneous with the event. So those are some of the skills that we use to try and make a call if there do happen to be no witnesses to the incident.
And I would imagine that would be a time when it is good to have somebody that is objective come in, because you don't know the fact that Sue often comes out of her office stomping and huffing.
Right.
You just know what happened on that particular day.
Right.
That Sue alleges she had some sort of an incident
Right.
occur.
Exactly.
I have another question that just came in. What do you do when the harasser is the big boss and all the other managers report directly to the big boss so their hands feel tied?
Well, if the complaint is brought forward, one would hope that someone in the company has the sense to say, we need to protect the company, not the boss. And that individual would make sure that HR is looking into it, or that if there's outside employment counsel, a communication could be made to outside employment counsel so that an investigation is undertaken even though it happens to be the boss who's being accused. If you happen to be in a corporation that has a board of directors, for example, oftentimes the complaint is brought to the board of directors who oversees the head of the company. So that's one vehicle that you can utilize. And one would just hope that there's somebody in the company who's going to realize that if they don't take care of this, it just makes things worse, because in the context of litigation, you've now exposed yourself to significant punitive damages, which is not where you want to be.
Well, I think you make a good point too when we tie it back to the policy, to make sure that your policy has some sort of a mechanism in place, right? Because some employers have policies that they've maybe gotten off of the internet or
Right.
something, or old policies, that just say, report it to your manager. Well, if my manager is doing the harassing or the owner of the company is doing the harassing, well, then I kind of feel trapped in a corner.
Right, every policy should have alternative avenues. Supervisor, but maybe, yeah, that's the one who's supervising you. Or you just don't have a comfort level with your supervisor discussing sensitive things. So there's normally 3 avenues that you offer to employees for them to complain. And once a complaint is brought to the attention of any member of management, it's noticed to the company. And that individual is duty-bound to bring it forward. Now, if it happens to be the president, you'd be bringing it forward to the president. But if you have a relationship with outside counsel, you can go that route and get their guidance on how do we handle this if we think we have a president who's going to try and shut down an investigation.
So that's a time where you may want to reach out to an expert too.
Correct.
Okay, there's 2 more questions in the queue. The first one is, what happens when an employee is aware of an inappropriate affair between 2 other coworkers?
Now it's getting juicy, right?
Well, remember, if it's consensual conduct, and this is a consensual affair between 2 colleagues, it's not sexual harassment. It may be inappropriate if they're cheating on their spouses, but it's not sexual harassment. That doesn't mean that you might not want to let somebody in management know about it, because consensual relationships can be problematic in the workplace. Because, if the 2 are now into a fight, now of course they're coming into work and they're fighting at work, or they're not cooperating with each other at work. It can get a little dicey. So an employer might want to know that there's a relationship going on so that they can maybe decide whether or not they want one of the individuals to leave, or whether they might want to separate these 2 individuals so that they don't have this baggage of the relationship interfering with the day-to-day workplace. Now, if it's a subordinate and a boss that are engaged in the relationship, that's a little different. That's something that the employer especially would want to address to make sure that it is indeed consensual, number 1. And number 2, to decide whether or not they want to allow that relationship to continue when the supervisor is having a relationship with a subordinate, because the rest of the group might say, she's going to get all the favoritism from him. How can I get a fair shake? So it's often not a great situation to be in, so the employer might want to address it.
Are there any other
We
questions?
do have one more question. Kathleen, I just hate to ask you, if you don't mind holding that microphone that Gonzo just handed to you, they're saying that they're having a hard time hearing you. There you go. Thank you. The other question comes off that they want to know, what happens if 2 employees tell each other off-color, inappropriate jokes often, and all of a sudden one day one of them decides that it's inappropriate?
Yeah, that's why I gave the warning that, engaging in those behaviors is very risky, because, while it was consensual, maybe now you've just taken it to another level. Your jokes have gotten dirtier and dirtier, and now it's gotten to a point where the other person truly says, oh, you've taken it a little too far. Well, now you're into the realm of perhaps engaging in some form of sexual harassment with that individual. The other might be, maybe the other individual thinks they're going to be terminated for poor job performance, let's say. And they think, oh, you know what? Maybe I can save my job by claiming all those exchanges weren't consensual, and I didn't tell the dirty jokes, I just listened to them, and I was truly offended. And they lodged that claim simply to try and preserve their job. Things like that do happen. It's not commonplace, but it does happen. So, the investigation that we keep talking about that is key will usually be able to determine whether or not it really was consensual and you're using this as a device to try and save your job, or whether or not it was consensual, but now one of the parties has gone too far and pushed the envelope to a point where it's no longer consensual.
That is all the questions that we currently have. Do you have any additional questions, Stephanie?
Well, I think one of the things that you said raised a question in my mind, which is, Okay, so historically, Stephanie and Sam have had this banter back and forth, and then all of a sudden Stephanie says, you know what, no. And P.S. employer, this started 5 years ago. So what we're even hearing now, not only are we hearing it in the workplace, but we're hearing it in the national news that this happened 5 years ago, this happened 10 years ago. What is an employer to do about those old allegations?
Okay. There is a statute of limitations, which is the time frame that an individual has to make a legal claim of sexual harassment. And that statute is generally 2 years. So if you claimed that you were the victim of workplace harassment 5 years ago, like many of the MeToo stories, they were stale. And that was the talk. They don't have a legal claim anymore because it happened too long ago. They're out of luck. That doesn't mean, however, internally, the employer shouldn't do something about it. They absolutely should, even if it did happen a long time ago. It should still trigger an investigation and some remedial measures and some punishment to the individual if they in fact did engage in those behaviors, even if they are stale. If you're able to come up with some evidence that it happened, you should take some action to ensure that it doesn't happen again. So you certainly don't want to sit on it. Because if you sit on it, let's say you get another victim next week. Well, now that victim is going to say, I want to know about all the other charges of harassment in the workplace and what did you do about them? And if you are saying, well, Stephanie complained, but her allegations went back 5 years, so we didn't really do anything about it, that's not going to bode well in the context of litigation. You're dropping the ball. So, even if they're out of luck from bringing a legal claim, that doesn't mean that they're out of luck insofar as, let me try to get some redress in the workplace to make sure that this doesn't happen again. And just to, so I don't get some pushback from people who know the law, there is what we call continuing violation theory. So, and it's an exception to the statute. So, for example, if you started being harassed 5 years ago and it never really stopped, and it's a continuing violation up until the present day, you're not outside the statute of limitations. You can bring that claim because it's continuing to go on. It's not stale. So that's the exception. It's continuing conduct. But if it stops, once it stops and ceases, that's when your limitations period begins to run.
So it sounds like the bottom line is anytime someone brings something up to me as a manager, I need to engage in some sort of a dialogue or some sort of an investigation to try to see if this problem is, you said that the 3 standards are reasonable, pervasive, and what was the other one?
It's unwelcome, severe or pervasive, and judged by the reasonable victim standard. Yes, so that all those elements are present. And a word of caution to anybody who happens to be a manager, and I've seen it several times, where the employee comes in and they say, I don't want to file a formal complaint. This is off the record, but I just want you to pull Tom aside and ask him to stop. Don't fall for that. You as a manager have an obligation to notify the company of what has happened and the complaint that you received. Because notice to you is notice to the company, as I've said before. So you can't honor that request for confidentiality. And you might want to even think about if someone says, and your manager, I need to tell you something, it might warrant, okay, I'm all ears. But, you have to know that if you tell me something I'm obligated to bring forward, I will be bringing it forward. Okay, give them that warning so that they at least don't feel that you breached their request to keep it confidential, because you can't keep it confidential. And if I do an investigation and I find out that a supervisor knew about the behavior long before it came to upper management's attention, I always recommend that supervisor be disciplined because they dropped the ball.
So we're just about out of time, but we do have one last question that came in.
We do. Someone wants to know how you can just determine between friendly banter or when someone is being inappropriate. Sometimes they feel that the lines can be a little blurred.
Yes, they absolutely can be, which is why I keep coming back to that theme. Engaging in these behaviors with people you work with is risky behavior. It would be better if we all kind of got the courage up to to say something. You know, put your hand up and say, you know what, I really don't appreciate that. You're kind of taking in a direction I don't want, so please stop. But again, that's hard to do. So it is difficult. And an investigator should be able to determine whether or not it's from the reasonable person standard. Now, that's where that comes into play. Would the reasonable person, be it female, male, whoever the victim happens to be, find it offensive? And that investigator will make that call. In the context of litigation, guess who makes that call? Who makes the call, do you know?
In the context of litigation?
Yes.
Judge, jury?
The jury. Those people sitting over in that box get to make that call. So yeah, it's a difficult call to make, but it has to be made, and the employer has to do their best to determine whether or not they think it was inappropriate and to a gravity that warrants some form of disciplinary action.
Well, I think we're out of time for today, but if you have a question that maybe you didn't get to ask, or maybe you didn't feel comfortable asking, whatever the case may be, you are welcome to email us, and we will be glad to put you in touch with Kathleen. You can email us at member411@njbia.org. You can also, if you want to contact Kathleen directly, you want to give your email address too?
It's KCONNELLY at Lindabury, that's LINDABURY.com.
Okay. Well, thank you so much, Kathleen,
Thank you,
for
Stephanie.
joining us.
Thanks for
And
listening.
again, please don't be shy. NJBIA is here to help with a sexual harassment issue or whatever other question that comes to mind. So thanks for giving us an hour of your time, and we hope you'll join us again.